Donald Trump prosecutors filed their reply to Trump's response in the 11th Circuit Court of Appeals, and we're going to go through it in detail. We've got the entire document queued up. Before we get into it, we're going to make sure we understand some of the legal terminology so that as we read it, we can keep our bearings straight. But this was a big battle, and the prosecutors are saying that as this evolves, they're saying that Donald Trump has the burden of proof, that he must prove that these documents were declassified, and they're trying to put the burden on him. And we're going to unpack all of that. But before we actually take a look at this response that came out from the prosecutors, you can see it's 15 pages, and we're going to go through it in a minute. I want to go and just make sure we understand some of the nuts and bolts of the entire motion, of the entire appeal. And remember that on this channel, we spent a lot of time talking about the different categories of documents that are at issue here. When they raided Trump's property, they left with 15 boxes. But in those boxes, there are all sorts of different documents in there. Some of these things were relevant to what we're talking about, and other things were just not relevant. And so when you start to pick out all of these documents, you'll see that some of them will fall into different buckets. For example, the attorney-client privilege bucket, the executive privilege bucket, the declassified versus classified bucket, which one? And also personal property versus presidential records, right? These are very important distinctions because with each one of these categorizations comes certain powers and privileges. They're like power-ups. I've got executive privilege. You can't look at that. And what's also important is that each one of these buckets might be used differently in different use cases. Okay, so for example, executive privilege might be applicable in certain situations and not in others. And in this case, we've got several different use cases that the documents might be used for. So what type of document do we have? And then what is it being used for? And there may be differences about what it could be used for based upon the different categorization of the document. So for example, a big batch of these documents was not even really relevant to national security issues at all, about 10,900 of them, in fact. So those could be applicable, let's say, to a civil review and a return of the records back over to NARA. These are just overdue library books after all. There was another category or use case of the documents which would have applied to national security implications. And remember, Judge Eileen Cannon carved out a separate exception for this, saying that the ODNI can, in fact, use this material to catalog any national security implications as a result of Trump's possession of the documents. And so you can see that some of these things might be relevant for the civil review and return. Maybe the executive privilege stops that, maybe it doesn't. Or maybe it doesn't in the case of the national security implications, where Judge Eileen Cannon said all of your privileges, all your classifications, all that crap doesn't matter because it's for national security. So you can see the type of document and how it's being used matters. But of course, the big one is for criminal charges. As we go through this response by the prosecutors, they're going to really want, one of the appealable issues here is whether they can continue their prosecution of Donald Trump. They want that to happen badly. And so now we have to ask ourselves, can these different buckets of documents, can attorney-client privilege, let's say, be used for criminal charges? Can executive privilege be used, let's say, for criminal charges? That's the home run. That's what the prosecutors want. They want those criminal charges and they want them bad, baby. And so now they have to ask themselves, can these different categories of documents be used for that purpose, for the criminal charges purpose? Some of it may not be allowed for criminal charges, but maybe yes for civil charges or for civil review and return, or yes for national security. And these are very difficult distinctions. But then we also have the burden of proof, and we're almost done here. The burden of proof in a criminal case, as we're very familiar with, is what's called beyond a reasonable doubt. That means it's if there's any doubt that's based in reason about a person's innocence or guilt, you can't convict that person because the government hasn't met that burden beyond that reasonable doubt. But in a civil case, it's much lower. In a civil case, we call it preponderance of the evidence, meaning if it's more likely than not, if it's like 51% more likely, then that's all that we're going to need to prove. The government doesn't need to prove beyond that reasonable doubt, which is a much higher standard. If you want to put a percentage on it, people say 80, 90%. Certainty. But it's civil, it's like, well, more likely than not. If you put it on a scale, it's like, well, just a little bit over. Preponderance of the evidence. Oh, just a little bit. More likely than not. And what we're going to notice is there's a big importance between these two differences because Donald Trump right now is involved in a civil case where the preponderance of the evidence is the standard, even though this is in contemplation of a broader criminal investigation. The special master is really only relevant in a civil context, and that's going to change the standards that we apply. So we'll come back to this Trump dilemma in a minute because there is a little bit of a dilemma that is popping up, and we'll come back and take a look at that. But before we do, let's actually make sure we can read through the motion and understand what is happening here. Government prosecutors respond to Donald Trump. They really want the 11th Circuit to grant their appeal and stop the special master from getting access to confidential documents. And in this 15-page filing that got filed in the 11th Circuit Court of Appeals, you see it is involving Donald Trump versus the United States of America. And this is a reply from the government prosecutors supporting a motion for a partial stay. So again, the prosecutors do not want the special master to take a look at these 100 documents, and they do not want to be precluded from criminally prosecuting Trump. And so Judge Eileen Cannon already said, that's too bad. Special master's getting those documents and you can't prosecute Trump. And they said, well, we're very angry about this. We'd like to talk to your manager. They filed this appeal with the 11th Circuit. The 11th Circuit is now being asked to undo what Judge Eileen Cannon did. Stay the original order pending the appeal. Let's take a look at what they write. Introduction and summary from government prosecutors. They say, 11th Circuit. The district court's injunction here, meaning Judge Eileen Cannon, her stopping us from doing our job is preventing the government from using its own records with classification markings, including markings reserved for records of the highest sensitivity in an ongoing criminal investigation into whether those records were mishandled or compromised. Right? They really want Trump prosecuted. And they're saying the judge is not allowing them to do it. The court entered that unprecedented relief to allow a special master to consider Trump's claim of privilege or for the return of records. They say Trump's response confirms that a partial stay is warranted because he cannot articulate any plausible claim for such relief as to the records with classification markings, right? They're saying Trump has the obligation to communicate that the records are declassified. They say, Your Honors, by the way, Trump scarcely even attempts to explain how those records could be subject to a valid claim of executive privilege, attorney-client privilege, or the return of property under the different rules. And so, as we talked about, there is several different categories. And what they're saying is, how do those categories apply to what we're trying to uncover here? They're saying Trump isn't even attempting to explain how they apply. Instead, they say Trump again implies that he could have, they put there in hard italics, that he could have declassified the records before leaving office, right? And that mere possibility, they're saying, Trump says is enough. The prosecutors write, as before, however, Trump conspicuously fails to represent, much less show that he actually took the step, right? They want Trump to prove that. They want that burden to be on him. And plaintiff is now resisting, meaning Trump is now resisting the special master's proposal that he identify any records he claims to have declassified and to substantiate those claims with evidence. And now they're referencing, right, basically minute entries is what it sounds like from the special master meeting, which of course we were not able to attend, unfortunately. I would have liked to have been sitting there watching this. But because these things all happen behind closed doors, and because this special master has sort of a direct line to Judge Eileen Cannon, remember the order said that Judge Eileen Cannon and Special Master Raymond Dearie can just sort of text each other. We were joking about this on the show. Hey, well, what do you think about this? What do you think about that? They're free to do that. So we don't know what happened, but they're telling us that it sounds like Trump's lawyers are rejecting a proposal, resisting a proposal. The special master says, you got to tell me what records were declassified. And Trump is saying we shouldn't have to do that. And so they're telling the manager, they're communicating this to the 11th Circuit. See, Judge, look, even at the special master proceeding, Trump's being uncooperative. So they continue, they say, all right, look, 11th Circuit, in any event, Trump's efforts to raise questions about classification status is a red herring. Doesn't matter anyways. They say, as the government has explained in prior motions, even if Trump could show that he declassified the records at issue, there would be still no justification for restricting the government's use of the evidence at the center of an ongoing criminal investigation. So they say, Judge, it doesn't even matter if he classified or declassified, regardless of that distinction, whatever bucket that's in, it's irrelevant. Either way, it doesn't stop us from prosecuting him. And they say, when we made this argument to Trump, he didn't say anything. He didn't even offer a response. They say Trump also fails to rebut the government's showing that the injunction is irreparably harming the government and the public, right? This is the national security argument. If they can't prosecute Trump and if they can't stop the special master from looking at those 100 documents, the government and the public are going to be irreparably harmed. We're all going to die. It's going to be like out of that scene from Indiana Jones where everybody's faces melt off their heads because of this slight delay of appointing a referee. That's what they've been arguing. He emphasizes that the district court allowed the government, meaning Judge Eileen Cannon, to continue to use the records for national security purposes. But Trump, they say, cannot deny that this injunction, meaning the stopping of the criminal prosecution, is impeding the criminal investigation, which itself, they say, is an essential component of the government's effort to identify and respond to the threats that were posed by the mishandling of their records, reflecting their extreme sensitivity, which I just don't buy it for a minute. I just don't. And the plaintiff cannot show that he would suffer any cognizable injury from a partial stay, right? These documents are so extremely sensitive that they're leaking them out to everybody. Washington Post had multiple leaks about these things. There's nuclear codes, and then there was other things, and nuclear preparation, all sorts of ridiculous stuff. And then all of it is sort of, forgot about all that stuff. Extreme sensitivity that they were okay with letting linger in Trump's residence, that it took Merrick Garland 3 weeks to mull over. Should I sign this warrant or what should I do about it? Right. So the extreme sensitivity that they exposed, they're now saying we have an immediate urgency here. Prosecutors deliver their argument. And we've heard this line repeated ad nauseum because this is just an appeal. They say the government is likely to succeed on the merits as to the records bearing classification markings. If it has the sticker on it, if it says it's classified, they say it's just the government's. That's just what it is. They say Trump has no claim of privilege or for return of the property with anything that has the sticker on it. They say Eileen Cannon recognized, the lower court judge, that they have limited equitable jurisdiction over the government's criminal investigation, right? Meaning she can't sort of commandeer the criminal prosecutions. Instead, what the judge did is stopped the use of evidence to recover that was recovered in the search warrant until it was reviewed by the special master for claims of return of property and the assertion of privilege. And what they're arguing here, they're saying Trump, right? Trump is the moving party. Trump is seeking that exceptional relief, and therefore Trump bears the burden of justifying it. But Trump has identified no plausible basis on which he could seek the return or the privilege of the documents. And they say that they've explained this before, and they have, right? We've already read through most of this probably 3 times at this point. But they say the government explained that Trump has no right to the return of those records, and they say that he has no standing at all. And they say Trump doesn't respond. Well, they say he doesn't have a persuasive response. I do think it's quite persuasive. They talk about this, right? And they're referencing this case, which we talked about previously, saying that if you seize some evidence that is personal effects, that you have standing to file a request to challenge the seizure, right? We talked about this. If any of the property that was seized out of Trump's residence belonged to him, in fact, right, that was actually his, and that is sort of not even being challenged, then he has standing to make a claim for the entire batch, right? They took one thing that was his, and so, okay, that gives him enough to open the door to say he can challenge that. But they're saying he cites no support for that authority. They're also saying that Trump implies that the Presidential Records Act gave him sole discretion to classify a record as personal before leaving office. But he doesn't represent that he did actually categorize anything as personal, right? So they want him to make the proof. They're saying that Trump has the authority, that he could have done these things, but the prosecutors are saying, yeah, but where's the evidence that you actually did it? They say any attempt to do so would have been contrary to the statute, which would have categorized it differently, right? Which is why they're saying he didn't do that. They say, third, plaintiff asserts that the PRA gives him cognizable interest because of ownership and interest case decisions that were made in a prior case. Take a look at this one, Judicial Watch versus NARA, which we talked about. And they say that Trump doesn't explain why a right of access constitutes an ownership interest, right? And that ownership interest is what they're saying is necessary to establish standing. Now, on this Judicial Watch case, they say the court held that it cannot compel NARA to revisit a president's categorization, but they say that grants no support for granting equitable relief to the court, right? So they're saying it's a different situation and it doesn't apply. And they move on in their arguments. Government prosecutors, they say, finally, even if Trump had established a property interest in the records that have the classification markings, he's still not entitled to release because we had a valid search warrant and Judge Reinhart stamped off on it. Therefore, we're in the clear. They say the records bearing classification markings are not subject to attorney-client privileges because they're not communications between Trump and his lawyer. And they're saying Trump doesn't argue otherwise. And I agree with that. I don't think he has argued that, I'm not sure why they're introducing that. Okay. Paragraph 3 says the government explained that any assertion of executive privilege would fail for 3 reasons. They're saying the current president sort of waived it for the outgoing administration. And they also say, we've talked about this, that if the incoming administration demonstrates a specific need for the material, then United States Nixon says that they should be able to go get it essentially, right? So they're both sides are referencing this Nixon case and they are using it for their advantage. Nixon is being split both ways. The prosecution is using it to say that if they need the materials, they can go get it, right? If a prior administration leaves with materials and the incoming administration needs those materials, they're citing Nixon saying, we can go get it. The Supreme Court says so. They said that in 1974. But Trump's people are saying basically the opposite of that, right? That the president has unilateral authority to declassify and declare certain things belong in a certain bucket. They say plaintiff should not be heard to assert a privilege that he failed to raise. And they're telling the court, they're saying, 11th Circuit, Trump doesn't even respond to any of these arguments. Except for a brief footnote, he doesn't even talk about executive privilege. And the footnote states that only other classified documents recovered before the search contained handwritten notes, and that those notes could contain privileged information. But they say the question is not whether the records here might contain material that in other circumstances could give rise to a claims. They're saying the question is whether the plaintiff can assert. Right? It doesn't matter if you could or might or whatever. It's right now, can you? Instead, whether Trump can assert privilege to prevent the executive branch itself, right, from reviewing the records that it says are central to its investigations. So this is just this is a brand new issue in this country. This is a crazy thing that's happening, right? The executive branch is reviewing records that are central of its investigation into a prior outgoing administration. And so it's pretty amazing. The 3 independent and unrefuted reasons why he cannot do so apply equally to the handwritten notes. And now we have sort of another category. You've got something that might have been classified that might now have executive privilege because Donald Trump scribbled something on it. They tell us, they write to the 11th Circuit, they say, Trump's arguments about classification and the status is totally irrelevant. In fact, they say Trump says that the government presupposes the documents are classified and that they haven't even proven that. But they say that's mistaken. The government prosecutors say, as we already explained, nothing in the motion depends on the classification status. The records classifications marking only establish that they're government records and that the responsible individuals determined that they could be damaging if released. Even if Trump had declassified some or all of the records, they write, that would not give rise to any claim of privilege or other basis for restricting the government's use of them. To the contrary, the government would still have a compelling need to review those records for its criminal investigation, right? And so again, we got to be careful about what we're talking about here. They're talking about not prosecuting Trump. They're saying they want the ability to conduct their criminal investigation at this stage. the investigation is separate from an actual prosecution of Trump. So we're not talking about whether Trump is guilty or innocent, in other words. They're just saying we need to continue our investigation. Second, they say even if the classification status were relevant, Trump gets the law backwards by saying the government must prove that the records are classified. They say the government already submitted detailed inventory and that records marked as classified are treated as such in absence of affirmative proof to the contrary. But now they say Trump, as the party seeking the relief, he bears the burden of proof. Yet despite multiple opportunities, Trump has never actually represented, much less offered evidence that he declassified any of the relevant records. And to the contrary, after persuading Judge Eileen Cannon to grant the relief and appoint the special master, purportedly disputed issues about the record status, they say Trump has now reversed course. In response to the special master's invitation to identify any records he claims to have declassified and offer evidence to support those claims, Trump objected, they put in italics, to disclosing specified information regarding declassification to the court and to the government. Right? And so this is where we get into the little bit of the Trump dilemma that we'll talk about in a minute. Now, in other words, why is Trump not wanting to disclose declassification status? We'll get into that. C, plaintiff's jurisdictional argument lacks merit. So they say Trump does not challenge this court's jurisdiction. And the appeals court, remember Trump filed a little portion of that where they said, Judge, they're asking you, they're saying 11th Circuit, they're asking you to reverse something that you don't have jurisdiction to reverse. And they're saying you got plenty of jurisdiction, court. Now, absent a partial stay, the government and the public, they tell us, are going to all die, irreparably harmed. Why? Interfering with the government's response to national security risks, impairing a criminal investigation into critical national security matters, okay, and forcing the government to disclose highly sensitive materials, which would only be going to the special master, right? So all of the FBI agents, everybody involved in this, the people who are leaking to the Washington Post, all of that is not irreparable harm, but disclosing highly sensitive materials to the special master for oversight, that would be a catastrophic, irreparable harm to the country. Got it. Yeah. Critical national security matters that were okay when they were sitting in boxes for 18 months, that were okay for 3 weeks while Merrick Garland was, meandering around with, whatever. So to the extent that plaintiff addresses these harms, his arguments lack merit, they say, as the government has already explained, and as supported by a sworn declaration that nobody cares about from the assistant director of the FBI's counterintelligence division. They say, and we read through this. This was from Alan Kohler. And Alan said, Judge, we can't separate the two out. We can't bifurcate our national security investigation from our criminal investigation. And so you got to just let us do our thing. And so they say the intelligence community says that they cannot uncover the full set of facts needed to understand this stuff. And under what circumstances? Because the FBI is just not that smart. The FBI, they say, has a critical role in using criminal investigative tools, such as witness interviews and so on. But this injunction stops the FBI from using the seized records. And Trump asserts that the government has shown that it would be easier to conduct that. But the injunction prohibits the DOJ and the FBI that they say are inextricable from doing what they need to do. Remember, they can't separate the two out. Alan Kohler said, well, Judge, it's like really hard. We're going to have to separate two teams and they're going to have to look at things differently. And that's a little bit too complicated for us over there. And so the prosecution is just saying that. It's not like it's going to be easier. They're saying, no, it's inextricable. It's impossible for us. We can't even catch the pipe bomber on January 6th. I mean, what are we going to do with spreadsheets? Trump, they write, next dismisses the government's national security concerns as hypothetical. Which, as far as we've heard, they are, right? The injunction is preventing the government from taking the steps necessary to determine whether those concerns have in fact become a reality. Yeah. Moreover, the plaintiff fails to address the harms that the injunction is going to stop the expeditious administration of the criminal law. What a stupid sentence to put in here. This is something you put in every motion if you're a government prosecutor. Judge, any delay here is going to be about interfering with the expeditious of the administration of justice. We've got to resolve these cases. And if you, judge, if you grant the defendant a 2-week continuance so that his expert witness is actually available, the gears of justice are going to just fall apart. We're all going to die. Same thing. Interfere by appointing a special master in an unprecedented raid of a former president. That is going to interfere with the expeditious administration of criminal law, right? And that the government's efforts are going to be obstructed, right? Yeah, they are going to be obstructed because nobody trusts either one of your institutions, the DOJ or the FBI. Plaintiff states that only the injunction will last for a short period. At the same time, Trump is already attempting to delay the proceedings before the special master. He wants to extend deadlines until late November. And why might that be? Well, because that's basically Trump's strategy at this point, is to win elections. Same strategy that Bannon has. Let the Republicans win, let the tides turn, the tables flip, and we'll see what happens after that. Prosecutors also say that finally Trump offers no response to the irreparable harm that will occur if they have to disclose this information to the special master or to the plaintiff's counsel. Plaintiff's assertion that the government would presumably be prepared to share all record verification is mistaken, they say. So if we give this over to the special master, it's going to harm the confidentiality and the national security of the United States. They tell the 11th Circuit that a partial stay is not going to hurt Trump at all. They're saying, Judge, if you give us back those 100 documents and you allow us to continue to prosecute Trump, it's not going to harm him at all. They say that Trump says that he could be harmed if it goes on unimpeded, but merely being subject to criminal investigation is not irreparable harm. The appropriate time to litigate challenges to a criminal investigation is through the ordinary criminal motions, not through civil action seeking to enjoin aspects of an ongoing criminal investigation. So do you see the benefit that the government gets by lingering this investigation on? You get a lot of criminal protections when you're charged with a crime. Right to counsel, right to remain silent. You've got all sorts of due process rights that exist. And when you're just investigated civilly, you don't get those same protections. And the burdens change, as we talk about. It goes from beyond a reasonable doubt, which is a very high bar for the government to meet, down to a preponderance of the evidence standard, where the government only has to show a little bit more likely than not. And so the whole power dynamic changes when it's civil. In conclusion, they say the district court's order, Judge Eileen Cannon's order, should be reversed to the extent that it stops us for our criminal investigations and to the extent that it requires the government to disclose those 100 records over to the special master for review. Signed by the usual suspects, Juan Antonio Gonzalez, Matthew Olson, domestic violent derangement individual who is over there at the DOJ, and the rest of the documents, of course, certificate of compliance and the certificate of service. Government prosecutors saying that this is a civil case and the burden of proof lies with Trump. Let's take a look at how this lays out on the mind map. The Trump dilemma is something that we are seeing him and his defense team running into now. Remember that when we summarize all of this, we can see that Trump is fighting a civil case right now. But this civil case has some criminal implications. Okay, it's a special master challenge in a separate filing taking place outside of any criminal charges. But what he answers here might have criminal implications for it, right? Because if he answers one way and says, I declassified everything, what happens if there was something in there that had been declassified that he should not have declassified, or there was some problematic document in there? And if he did declassify everything and he communicates that he did declassify everything, now what the prosecutors will say when they turn around and charge him is that he had knowledge, that he had intent, that he knew everything that was in there, right? And so when he was posting stuff on True Social saying things like, I declassified everything, so it's not a problem. You say, okay, well, what if there was something in there that you didn't think you declassified and the government slipped it in there or they did something? What could have happened? Let's explore that. One, the General Services Administration could have screwed something up when they're packing Trump's office up and taking him out of the White House. Maybe something got cataloged in those boxes that shouldn't have been there. And if Trump says, I knew everything that was in there and I declassified it all, that makes him personally connected to it via knowledge. But there could have been something else where Trump was completely unaware of anything in there, and an aide packed it, or just the GSA packed it, and Trump really had no knowledge or no intention on anything that was in that box or in those boxes. And so that breaks that sort of mens rea element of the criminal charges, which is something we talk a lot about here. Remember, in any criminal case, in most criminal cases, you have, depending on the charges, you have two types of elements that are required. You have a mens rea, a mental state, and you have an action. You intended to steal the candy bar and you took it past the point of sale, right? You had a mental state, I'm going to take this and not pay for it, and then you did it. A mindset and an action. Here, they're going to try to show that Trump had the mindset, right? That he had knowledge, that he had intent, that he was behind the seizure of these documents. They want to get to him. So how does Trump insulate himself from some of that? Well, it's aides packed it, or aides planted it, or Trump was unaware of it, right? This is all overdue library book nonsense that the head librarian of the United States instigated at the behest of the Biden White House. Or, of course, based on some of the prior actions from the FBI, it's not insane to think that the FBI planted some documents or manipulated some documents based on several things. One, all of the prior manipulations that the FBI has committed historically, not only at the FISA courts and Carter Page and Michael Steele and Michael Sussman and that whole saga, but they also manipulated evidence in this case. They took a bunch of documents and threw them all over the ground. And they assembled them in a way that, as far as we can tell, was manipulating the picture, right? The boxes in the inventory that we got, the more advanced inventory, showed us that there were boxes that looked like 1,000 documents that were not a problem and one document that was a problem. Sort of a big ratio of 100 to 1. And so what we saw there was this compilation, this collage of all of the worst pickings that they just assembled for maximum effect. So if we know that the FBI has a history of lying, if we know that the FBI has a history of colluding, has a history of setting up the former president, and has been involved in all sorts of political scandals against this president in particular, it's not insane to think that they maybe did something that might have rigged this investigation at all. I think it's actually very reasonable. So as you can see, when you explore those potential dilemma sort of outs, the big problem, of course, is that the burden of proof right now in this civil case, Judge Raymond Dearie might say it's on Trump, right? He actually does have to prove something, show up something, make a showing that these documents were declassified because it's a civil matter. And what he says there could be applicable in a criminal case if that goes back over to the DOJ, right? And so there's some serious precariousness that's going on right here. So we're taking a look at what Trump's defense attorneys are saying. You can understand why they don't want to make that proffer to the special master to say, we don't want to tell you about those because we know that what we say is going to be used against us. But the special master at the same time can say, well, the government, this is only a civil case. They haven't charged you with a crime. And so you don't have those same protections that accompany criminal proceedings, which is why the government wants to leave this in a civil limbo as much as possible. Because as soon as you get charged with a crime, you get all these protections that come into play. You get all sorts of privileges that don't apply in civil cases. The big blind spot that we have, and we don't know what is reality, but what are the documents? And my big question is, does Donald Trump even know what was in the documents? Does his defense team know? Or were these just boxes that somebody just filed away somewhere? And they're like, well, we'll go through those next year. You know, we have to, what's in those boxes? Maybe it's in one of those boxes somewhere over there. Go check in there. Do they even know what's in it, right? Do they have an inventory? If they do, then they're playing with a bunch more knowledge that allows them to be more strategic about this. But if they don't, then their hands are a little bit tied. And we're going to see what the 11th Circuit does. Remember, this is the court docket. And we can see new parties are filing into the case. This is what the docket at the 11th Circuit looks like. Amicus brief was already filed by a number of different states, and we covered that previously. We had some filing deficiencies, some corrections that need to be made by a couple of the appearances of counsel. But that was the appeal, and that's the final filing until the 11th Circuit issues a ruling. And they're going to be telling us more about whether the criminal investigation can continue and whether the special master can obtain and maintain those possession of those 100 documents. And regardless of how it goes, you can pretty much imagine that both parties are going to be appealing this puppy over to SCOTUS immediately. If the special master stay is granted and the criminal prosecution can continue against Trump, probably imagine they'll appeal it. And if it goes the other way, you got to imagine that the DOJ appeals it as well. And so we'll continue to cover it either way. Thank you for subscribing. Thank you for liking this video and sharing it with a friend who might also be interested in the Trump prosecution that never ends. We'll continue to cover it.